Good morning. May it please the court, my name is James Krasnew, and I represent Richard Disler. Mr. Disler was charged in one count with violation of the child enticement statute. Your Honor, none of the enumerated offenses contained in that statute can be performed through a computer. You cannot have sex through a computer.
But this prohibits enticement.
And
not sex, enticement.
And enticement, Your Honor, has to be accompanied by some kind of physical act beyond mere speech.
Why do you say that? I don't understand where that comes from.
Because otherwise it's a mere speech, a crime. You are basically putting someone with words on the net, and when he puts it on the net, he has no way to know that any recipient on the other end is a child. And the reasonably believes language is unconstitutionally vague. Merely because a human being on the other end says, I'm 14, does not make him, her, or it 14.
It doesn't matter. The statute prohibits, as you suggest, enticing someone a person reasonably believes is under 14.
But there's no showing that the defendant reasonably believes, merely because another person on the other end says she's 14, that she is 14.
Didn't he say, come to my house, meet me at my car?
He said it constantly.
Didn't he go off in a black Lexus to a certain point to meet?
He said it constantly.
And didn't they see him at that point in the black Lexus?
No. Not the last point, Your Honor. He constantly reiterated, come to my house, come see me, without ever giving an address.
What about the car?
He constantly said, come meet me at my car. But no meeting ever occurred, and there's no showing that anyone tried to meet him there.
But the crime was complete as soon as he invited someone that he believed to be a minor to his home, intending to commit one of those crimes.
Your Honor, that can't be so, because if it is, if I turn to you and you're 14 on the street, and I can assess your age, and I turn to you and I say, boy, would I like to have sex with you. And then I decide, well, you know, you're rather young. Why don't we postpone it for 2 years? I have not enticed. I have not induced. And I have not committed a completed crime. Because if I have, then what Judge Katzmann said in Bell makes no sense at all. There has to be more than mere preparation.
But you haven't enticed by saying, boy, would I like to have sex to you. Entice means lure. You haven't lured. You haven't induced. You haven't persuaded.
She says to me in response, you know, you're a good-looking guy, which would be an act of misjudgment in real life. But she says, I'd like to go to bed with you. And I say, you know, that'd be wonderful. Here's what I'd do to you. I would touch you in places you've never experienced. And she says, that would be wonderful. And then I say, you know, you're only 14. Let's wait a couple of years.
But that's not this case.
It is in the computer.
He said, come over to my house. Meet me at my car.
And
luring.
The mere statement of those words cannot be luring. They have to have an intent for fulfillment. They have to have an intent for fulfillment. How do you distinguish that from someone who cannot possibly meet at a car and cannot possibly meet at the house? For example, 14-year-old is on the net and meets another 14-year-old. One of them says, have you ever had sex to the other? The other says no. That person says, here's what I do to you. And the person who's receiving that information says, that'd be wonderful. Let's get to it. I can convince my parents to put me in a car and take me to where you are. Where are you? Oh, I'm in Seattle. Where are you? I'm in Boston. Is that a completed crime? And if it is, does Your Honor's wish it to be a completed crime? And how does that give knowledge, a reasonable knowledge, that the person is not under a vague statute, but that it actually applies to him? How does a person of common intelligence know that he is committing a crime by saying exactly what one 14-year-old has just said to another over the net?
Well, it might be a crime. You're hypothetical, but that's not this case.
This
This guy wasn't in Seattle. He was right near the victim.
How did she know that, the victim?
Meet
She
me-
never gets an address.
He said, come meet me in my car at the T station. So
Yes,
Today.
he did. He said that at the very first time, and when she asked for what, he said we would talk. Does that show an intent to commit one of the enumerated offenses? Is it complete then? You can't have it that if those words are going to do it, is it complete each time he says them?
Well, there's a tremendous amount of evidence with respect to intent that we would ordinarily consider more than adequate. I mean, there are all kinds of conversations he's having both with this person and others about his desire to have sex with a child.
Your
I
Honor,
mean, there's no question that ordinarily, if one says, I'm really interested in killing my spouse.
If Your Honors find that under this statute, then Your Honors are ignoring the tons of cases out there that recite over and over again. Mere speech is evidence of an attempt to ensnare. But
It's also evidence of intent.
it may be. But it also must have some corroboration. And they usually hold, in all of the cases that I've read, they usually hold that making a specific meeting place and getting there, or attempting to get there, or telephoning, taking it beyond the net into a telephone, or sending a letter, or sending a gift. There are various cases that abound that way, but just to hold the speech on the net does it?
So if I go on the internet searching for someone who will kill my spouse, and I find someone who says, sure, no problem, be happy to do it.
Right.
What would you want me to do? And you describe what we like to do, and the guy says, okay, or whoever it is says, okay, that's fine. That's not solicitation to commit murder?
That's right, Your Honor, because it's missing one important detail. And don't confuse solicitation with enticement. The reason why the federal statute and so many others put in those magic words are its attempt. Here, Mr. Disler is charged with the completed crime. There is no completed crime in your example for a very simple reason.
Isn't
The
the
person who wants to murder doesn't know where the victim is. He can't get there yet in what you gave.
Could I suggest to you that the crime is completed when they reach an agreement to meet, which is what we had in this case? Meet me at my car at 4:30 or 4 o'clock, whatever it was, and she, in quotes, says, I will. Agreed. An agreed liaison.
An agreed liaison is still merely words. What happens if she meets there and she's 19? Has he tried to entice a minor? How does he know that it's a minor? Your Honors have to ignore, in order to ask even the questions that you're asking, you have to ignore Ashcroft and Reno that point out the difficulties of knowing age. We're not at the Pittman case where there's a face-to-face meeting and you've got to be sure.
Told him how old she was.
People lie on the net all the time, Your Honor.
They do?
Yes, and it's said in Reno and it's said in Ashcroft. And it's obvious that they do. And in fact, it's stated as facts in one of those two cases that the United States Supreme Court found that people misrepresent on the net all the time.
So just on that ground alone, all these child enticement cases can get thrown out, because when there's a cop at the other end, it's no good.
No.
They're lying about their age.
No.
No?
No. That's one problem with the statute, the question of age. But it's a problem here because there is no corroboration to Mr. Disler's words. How do you distinguish Mr. Disler, if he's a fantasizer, from Mr. Disler, the enticer, by whatever he says? Your Honor asked in the earlier argument whether or not there could be a simulated act that was used for therapeutic purposes. In this case, I analogize to that. People can be on the net. They can be people who fantasize what they would like to do to children. They can announce it on the net, both to children and adults. There is nothing illegal about that. They must have the desire to lure someone out of a building, entering a building, etc., that portion of the statute, and They must intend to perform one of the enumerated acts. Now,
we agree. I mean, I agree. You have to entice, and here the question is, was there sufficient evidence of enticement? Yes, meet me at my car, or meet me in my house, or whatever. And they have to have the intent to commit one of the acts. Well, intent can be proved by the statements of the person as to what he intends, and that seems to be present here, too.
I think that you are punishing a speech crime which there is not a single word Mr. Disler said which is said to an adult would be a crime.
But it doesn't matter because the legislature may have been intending to deter people who entice children who they believe are under 16.
However, laudatory, they've got to do it in the least restrictive way possible because it involves pure speech. They didn't do that. There's no requirement here of filters. The Ashcroft case talks about, that's one of the reasons they threw out the COPA statute, because they said there are more restrictive alternatives than just regulating free speech. Mr. Disler's speech is free. He could say those things to any one of you, and suddenly the moment one of you say, well, you know I'm 14, and he continues to say it, that makes it a crime? Without more? The answer is, if you do that, you virtually chill all speech on the net that goes to sex all the time.
Counsel, let me ask you, if he had given an address, would that have been enough?
It certainly could have under some circumstances, but not others. Twice, we have Mr. Disler refuse her stated willingness to come to his house. I'll take a cab up. No, not tonight. Well, what are you doing tonight? Well, I'm watching television. You sure you haven't got someone else you're going to be with? No, I'm sure. I'm not. What happens when someone rejects? You had that problem in Philopolis. That's the only areas where we can join, because Philopolis entered on a path that is not a path Mr. Disler went on. If you punish Mr. Disler by convicting him of this crime, you have virtually said that any time anyone gets on the net, and while you're on a set of my 14-year-old, well, that isn't our case. It is in terms of overbreath. Mr. Disler has standing to raise that. So decide what you're doing to that 14-year-old, actually to both of them, because both of them agree to commit the crime of enticing each other. They just can't physically do it and do it ever. Is it just wishful thinking? How do you distinguish wishful thinking, which is permitted speech, non-obscene permitted speech, even if atrocious and horrific? You must distinguish it. And this statute fails to do that. And I might add, I think fails to do it miserably. If you look at this statute, it is a hodgepodge of bits and pieces from statutes taken around the country. The amicus brief points that out. But when you put it all together, it doesn't work. And why the legislature, knowing the difficulty on these crimes, did not put in, or its attempt, which language abounds in countless numbers of statutes, including the federal. Over and over again, however, it is made very clear, in this Commonwealth at least, that attempt, which is what solicitation really is, and solicitation involves two people coming to an agreement. By definition, a child is incapable of agreeing and cannot. The mere fact that they say they do doesn't mean that they have the power to agree, unlike adults. But if we get past that to the reality of this statute, the reality of this statute is that it punishes simply words. If Mr. Disler said, I'll meet you at McDonald's tomorrow, I'll be wearing a red hat and I'll be in my black Lexus, and a black Lexus with a red-hatted person shows up at McDonald's the next day at the approximate time, he has now corroborated his intent. He no longer is simply someone who says whatever he wants on the net and fantasizes harmlessly, if deplorably. He is someone who is now trying to entice the child. When Mr. Disler simply remains at his computer, He has not yet committed a fulfilled crime. He has only manifested his intent. And if you find otherwise, then what you do is punish the millions of people who use the net for free, if deplorable, speech, not knowing whether or not the person on the other end is or is not an adult.
Thank
Thank
you,
you.
Mr. Krasny. Mr. Steinfeld?
Thank you. Good morning. May it please the Court. Kenneth Steinfeld for the Commonwealth. The principal issue before the Court is to determine, pursuant to the statute, the moment at which child enticement occurs. Now, Justice Graney suggested earlier that it could be at the moment that the girl agrees, or the person purporting to be the girl agrees to meet him at the car, but I would suggest that under the statute it permissively prohibits the sole transmission of the communication regardless of what the girl does at the other end. So in other words, if somebody invites a person he believes to be under the age of 16 with the requisite intent, that is still child enticement, even if the child says, "You're gross," and runs away the other way. It doesn't matter. The legislature has chosen 8 words to define entice, and the principal one of them, I think, is the word invite. Judge Riley below said he wanted to focus on the word invite, and I think he did so wisely. I think that word is different from the other 7 in that it cannot be interpreted to take into account what happens to the recipient of the message. It solely focuses on the intent of the person who sends it. Did he?
What if the person sends a message out on the internet saying, "Is there anybody out there that wants to have sexual relations?" Is that enticing a minor?
No, because this is different from the Reno case and the Ashcroft case, which is similar to that. Those statutes might have prohibited that. Here, the Commonwealth has to prove beyond a reasonable doubt that the defendant subjectively believed that the recipient of his message was a person under the age of 16.
Is there anybody out there that wants to have sexual relations? He's covering the gamut. He's not just limiting it to adults.
But the Commonwealth would also have to prove that he had the intent to commit a sex crime or an act of violence against a child while he reasonably believed that the recipient of the message was a minor. So if
he doesn't care who's out there, including minors.
Well, then the Commonwealth would not be able to sustain its burden of proof of showing that he subjectively believed that the recipient was a minor. Or the Commonwealth would probably not be able to prove either that he had the intent to commit a sex crime or an act of violence. That is just a general solicitation for sex. The fact that a minor...
Now, if he sent out the kind of generic message that we're talking about now, he wouldn't even be charged. It's only when it focuses on someone under 16, as this defendant did.
Yes, absolutely.
How old are you? Well, I'm 13, and so forth.
Yes, absolutely. The statute is narrowly written to reach just those situations. It is not a broad-based statute such as those that were struck down by the Supreme Court in Ashcroft and in Reno.
How do you respond to Mr. Krasner's argument that the statute doesn't distinguish fantasy speech?
Oh, I think that the intent requirements would cover that. A jury has to believe beyond a reasonable doubt that the defendant, when he transmitted the invitation or the enticement, had the specific intent to commit a sex crime. A person who is fantasizing does not have that specific intent. It's a question for the jury.
But your brother says you can never know that the person who says I'm a certain age is telling the truth. So if you don't know that they're a minor, you can't hold them responsible for attempting to entice a minor.
But you can, I would say, hold him responsible if the Commonwealth proves that he believed that the person was under 16, just as...
And the belief would be based on the representation.
Based on the context of the conversation. There was so much evidence here from which a jury could have found, Judge Riley could have found, because it was a bench trial, that he subjectively believed the child was under 16. The nature of the questions that he...
That may be the case, but he has raised the broader case, so we have to deal with the broader.
Pardon me?
That may be the case here, but he has raised the broader issue. He has raised the broader issue. I mean, I'm not even sure that it is the case here, but he has raised the broader issue. And you're simply saying that that he can fantasize, that one can fantasize on the web as much as one wants to, but if a jury decides that you actually intended, even though there was no action, I mean, I think that is what goes to the heart of Mr. Klasner's, that there was no action taken. He didn't show up in a black Lexus with a red baseball cap. That nevertheless a jury may conclude that he intended to take some action.
That's simply a sufficiency of the evidence question.
Certainly. I think that is what the statute says, and that it permissibly says it.
Is this case involve both a facial attack and an as-applied attack?
Yes, it does. But I would suggest that the facial attack has no validity whatsoever, because, as the federal courts have said repeatedly, and it's rather obvious, there is no First Amendment right to solicit sex from a child. And the statute contains two provisions that make sure that in every single case in which a defendant is charged with child enticement, the speech does not involve First Amendment protected speech. The first, of course, being that he reasonably believed that the child is under 16, and secondly, that he have the intent to commit a sex crime against a child or to commit an act of violence. There's no court that has ever held that type of speech, what the federal courts have called a targeted inducement of a minor for sexual purposes, is completely outside the scope of the First Amendment. Therefore, there is no overbreadth challenge that can be brought here whatsoever. And here, as to the as-applied, I would merely argue that the record was replete with evidence from which the jury could have found those two things satisfied, and therefore the statute was not unconstitutional as applied to him. Because the jury...
Go ahead.
I'm sorry. I thought Your Honor was going to ask a question.
I was going to ask you, I think you mentioned in your brief, what is the statute that comes closest to ours?
I don't know if any that has the same combination of factors as ours. I know there are similar statutes. I believe it's either Wisconsin or Wyoming, and I was not able to memorize which one it is, says a person who is under the age of 16 or someone who is purported to be under the age of 16. And that is the closest that I found here. The standard here is much more favorable to the defendant because it gives him the defense of subjective belief. Justice Cordy suggested earlier that the statute provided that it be a reasonable belief that the child be under 16. There is no such requirement that's in the statute. It is mere, and that's another boon to the defendant. It doesn't, he can show under the circumstances that his belief, that he did not believe that the child was under 16, even though she said she was 14. The defendant did exactly that in this case. There was, in fact, a good deal of evidence from which a person could have believed that this person was not under 14. You know, several of them, he claims she didn't believe that she was 14 because she said she was Jewish and yet her last name was Irish. There were a bunch of other inconsistencies that the child made. She said at one point, I skipped school, and then she later said the teacher let me out.
So you need to prove that the defendant actually believes.
Absolutely.
If you read the language of the statute.
Absolutely. Subjectively, it's not. There are a lot of statutes that are broader than this one that say not just believes, but knew or should have known. Here, there's none of that.
Yeah.
So this is different than reasonably believes, which is what we were dealing with.
Absolutely. This is, the Commonwealth has a burden to prove beyond a reasonable doubt that this defendant, when he made this communication, knew actually, or I'm sorry, believed. And of course, that is subjective. There's no way to get inside the defendant's head to prove it directly. You have to use circumstantial evidence, and here there was an abundance, I would say, of circumstantial evidence to prove that.
And that would encompass someone who, in fact, is over 16, but if he intended to entice a person under 16, he would be guilty of violating the statute.
Yes, that's the case here, where the undercover officer...
Right. It would encompass... Right, but in case someone were over, but he believed he thought that person was under, just over, it would include that person.
Right. The fact that the person is not 16 does not matter.
Right.
Mr. Steinfeld, you referred to the Wisconsin statute. I haven't read the Wisconsin case, but if I believe the amicus brief, the Wisconsin Supreme Court took a position slightly different from yours, saying that the mere that the solicitations, the internet conversations, all of them, which were pretty explicit, could be introduced as evidence of enticement, but you needed some act. In that case, the person showed up. In other words, it could be an undercover police officer because it was targeted. It was targeted to an undercover. It was targeted to somebody who was representing themselves on the net as being under the age of 16. But that you needed actions in furtherance of that intent.
I was just referring to the statute itself and the language regarding the belief of the age of the person. The statute is different. I'm not sure, but I think in that case it was an attempt, and this is not an attempt. So there'd be the requirement of an overt act, which is not the case here because we've got a completed crime. But I just was pointing out that the statute itself contains different language. I was not saying that the statute's exactly like this one, and I don't think that any court has taken a statute like ours and said that there has to be more than just the mere transmission of a message. I think it's very clear that the legislature chose that time for a very good reason. It decided that the best way to prevent and prohibit the sexual abuse of children was to nip it in the bud as quickly as possible. And so as soon as the message is sent, that is the enticement. And the legislature did not want to wait and see what the recipient, what a child did with that information, whether he or she acted on it, whether there was a meeting or not. I suggest to follow my brother's argument would be to endanger children, to require...
How about if you take the example which one of my colleagues mentioned, is that you've got two 16-year-olds on the net, and one of them's in Seattle and one of them's in Boston. Can they both be, at least the Boston one, because the Massachusetts, because
Sure.
you would have jurisdiction over the Boston one, can be held liable for, can be indicted under the statute?
Certainly. There are many cases in which people have traveled from different continents, from different countries.
There's no travel. Meet me, sure, we'll meet. You agree to meet, and then says, by the way, where are you? I'm in Seattle. Oh, darn.
Well, the invitation has been made. The requirements of the statute have been fulfilled, and I don't see any problem criminalizing that, although it doesn't ultimately come to fruition. The intent when the transmission was made, that very moment the crime has occurred. And so anything that happens after that is superfluous.
So this applies to any of the emails that are going back and forth among school children in Massachusetts. Meet me for a date. I want to have sex with you. So all the school kids who are emailing, and if you think they're not, you don't...
Well, I hope they're not.
Well,
it could.
they certainly are, and they're doing it backwards and forwards, but they're not actually meeting.
Sir.
And it's a little hard to know which one of them is enticing. They're both enticing.
Sure. The statute could be read to apply to such a situation.
Well, it does apply to that.
Yes.
By your definition.
Yes, but I think that would be a tiny, tiny fraction of the behavior to which it would apply.
Why?
Because...
if there's
frankly,
there are massive numbers of adults who probably don't engage in emails involving sexual issues, judging by just popular media, it's hard to get anybody to be successful under the age of 16 unless they do engage in sexual messages.
Sure. There's no evidence, and I frankly don't know what the popularity of such messages between 14-year-olds is.
Guess? You won't guess.
No. So I can't answer that specifically, but I think that the permissible reach of the statute is so broad. And while I would never rely solely on prosecutorial discretion, I would think that it would be a rare case indeed in which a prosecutor would bring a case like that. If it did, then I think this court could look at that question. I don't think that I think that should be raised as an as-applied challenge rather than as a facial challenge, especially given the lack of evidence below or here as to the popularity, the occurrence of those conversations. So I admit that it could be applied in theory to situations in which it was not intended and in which we all are...
It would be hard, based on your reasoning, hard to know why that as applied challenge would succeed, because the intent, you would have said under what would now be the precedent of Commonwealth against Disler, was completed. And we may not like the fact that the prosecutor is targeting, 16-year-olds who are communicating with each other, but that's not our job. That's your job.
No,
And
but
so
16-year-old...
it's hard for me to see how, if it fails here, it would succeed in an as-applied challenge.
Well, I can see your point, and also that my time is up. But I think that... I'm sorry, could you ask the question again, please?
Certainly. If we were to agree with you that the crime is completed regardless of any subsequent act because of the two specific provisions that you identified in the statute, and if there are communications on the web between two 16-year-olds, but that are not accompanied by any meeting or act, neither one of them shows up, they just continue to have this on the web chat, but it meets all of the requirements that you say is all that's sufficient to complete the crime. You said you don't rely on prosecutorial discretion, but you could raise an as-applied challenge, and it's hard for me to see how, if we were to agree with you in this case, in Disler, how once we say there's no facial problem with this, how an as-applied challenge in the circumstances that I gave could possibly succeed.
Yes, I see. I do agree that for say 15 or 16-year-olds, that is a problematic issue, that an as-applied challenge would probably face the same issues as an overbreadth challenge here. But I think for children at a younger age, it may be the case that a person of that age is not capable of forming the requisite intent, and therefore a child asserting an as-applied challenge would have a better chance of showing that he could not have satisfied the elements of the statute that way. Thank you very much, Your Honor.
Thank you. We'll take a short break.